It is August 19th of 2026, and this is the Court Gallery. Today's cases are packed with defendants who just don't know when to stop talking. First, we visit Judge Elmore's courtroom where a man tries to explain away his threatening behavior as scream therapy, leading to a deeply philosophical judicial lecture. Then, we switch over to Judge McNally, who faces a series of increasingly frustrating defendants. From a woman who can't stop interrupting during a Zoom hearing, to a driver with 14 warrants who thinks it's all a joke, and a serial shoplifter who comes back to complain about her sentence. Are these defendants ever going to learn when to stay silent, or will they talk their way right into the jail cell? All that and more start right now.
We are on the record now again from 28th Circuit Court here in Wexford County. And we are taking up the case of People of the State of Michigan versus Aaron Dale Seibel. This is case number 24-13962 FH. Appearances from counsel, beginning with, I assume, an assistant AG. Go ahead, sir.
Special Assistant AG, Your Honor. Robert Ianni, I-A-N-N-I, on behalf of the people.
All right, thank you.
Robert Hartzell for Mr. Seibel, who joins me to my left, Your Honor.
Thank you. Also here before the court this morning is Mr. Kevin Steffel, the Michigan Department of Corrections, serving as the probation officer today on this file. The last on this record for this case back on August 11th, there was a request to have a formal hearing, and that was requested to be conducted within the 14 days of the original arraignment. That original arraignment occurred on or about, I think, August 5th. Let me double check here. Yeah, on or about August 5th. There then was a request by the assistant AG for an ex parte motion to adjourn the contested hearing, which this court granted last week. And so now we're here for the contested hearing. Before we begin that, Mr. Hartel, is that a fair summary of what we're here to do today?
Yes, it is, Robert.
All right. Sir, I didn't write it down, but I'm going to now. What was your last name again?
Robert, last name Ianni, I-A-N-N-I.
Ianni. All right. Thank you, sir. You may begin.
Good morning, Your Honor. People would first call probation agent Kevin Stapleton.
Yep, sure. Mr. Stapleton, you may come forward. First of all, the court will take additional notice of the terms and conditions of probation that are contained here in the file. And let me just acknowledge when those were signed by the court and by the defendant. Looks like I signed them on April 1st of 2026. And then they were subsequently acknowledged by the. All right, Mr. Stapleton, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, I do.
You may have a seat. And 1 second. All right, thank you. Mr. Ianni, go ahead.
Mr. Stapleton, just for the record, just state your name again and your occupation.
Kevin Stapleton, I'm a probation officer with Wexford County.
In the course of your duties, did you come to know the defendant in this case?
I do. I am the probation officer on record for the defendant.
Is the gentleman next to counsel?
He is seated at the defense table, yes.
Did it come a time that you violated Mr. Seibel for his violation of his probation?
There was, yes.
And what caused you to do that?
It was actually, it was a date as August 3rd there was an incident. The defendant exhibited some intimidating, threatening behavior towards the prosecutor's office.
How did this come to your attention?
My partner over in Lake County, Luke Blazak, was present, and it was also the deputies that notified Luke as well that an incident had happened.
And what information did you receive?
Ultimately, I received a police report that indicated the exact details of the incident. That was written by Detective Nate Edwards over in Sauk County Sheriff's Department.
What led you to believe that this constituted intimidating behavior?
It was based on the police report and the description of the events. The defendant was pounding his fist on the counter, pounded on the glass at one point, was screaming so loud his gum flew out of his mouth. He was, like I said, it's threatening and intimidating behavior is basically just that. It doesn't have to involve any exact threats towards the prosecutor or the.
And which condition of his probation did you believe he violated?
I don't know the exact condition. You must not exhibit any assaultive, threatening, or intimidating behavior. Like I said, I'm not sure the exact number of it's in my file.
I would say that was condition 4.18.
That would be accurate. Yes. Yes.
I have no further questions.
Thank you, Mr. Hartel.
Yes, sir. You mentioned reading a report from Detective Edwards. Is that correct?
That's correct.
Do you remember a line in there that says, and I'm going to quote here a little bit, no physical assault or verbal threats of violence were reported? Do you remember that quote being in there?
I do.
Okay. And you still felt that this rose to the threatening behavior?
Yes.
Could you explain why?
Threatening doesn't mean a direct threat. Threatening behavior can be just holding your fist up at somebody, pounding on the glass, pounding on the counter, raising your voice, anything like that can be threatening behavior. It doesn't necessarily, like I said, it wasn't a direct threat. Yes.
To confirm, you didn't physically observe this. This was based on what you read in the report.
Yes, that's correct.
Did you talk to my client at all about that afterwards?
No, I did not.
I believe you answered my questions. Thank you.
Thank you. Anything further?
Nothing further.
Thank you, Mr. Stapleton. You may retake your seat. Yes, Mr. Ronnie.
Our next witness is Sheila Morgan.
Ms. Morgan, please come on forward. Raise your right. Ma'am, do you swear or affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes.
Ms. Morgan, you may have a seat. Mr. Ronnie, the floor is yours.
Ms. Morgan, just again, for the record, tell us your name and what you do for a living.
Sheila Morgan, Business Office Manager and Records Custodian for Missaukee County Prosecuting Attorney's Office.
And I'll likewise ask you, are you familiar with the defendant in this case?
Yes.
How do you know him?
He has made multiple phone calls to our office, some voice messages, and he was in our office on August 3rd.
With regard to these phone messages and visit that he had to your office, is it the routine practice of your office to record these conversations?
Yes.
And contain the ordinary course of business?
Yes.
And may I ask you to take a look at what we're going to call this, if I may approach you.
Of course.
We're going to call this thingamajig, people's
Flash drive?
proposed exhibit 1.
Okay.
And if you would just look at it and tell us what exactly it is.
This is a flash drive that I downloaded a copy of the voicemail left by Mr. Seibel on June 25th. And it's a copy of the video from our office on August 3rd.
You made that flash drive yourself?
Yes.
And did you copy it from the original audio and video files that the office maintains?
Yes.
It hasn't been altered. It's exactly as recorded.
Yes.
The people is proposing that one be in evidence.
I may have just some brief for it, Your Honor.
Of course.
Ma'am, to confirm, to your knowledge, is that just one phone call or is that all the phone calls it provides in the defendant's office?
This was just the one phone call from June 25th.
Okay. I don't believe I have ample grounds to object, Your Honor. I'll save anything else for cross-examination.
I will stipulate that there were other phone calls which were not threatening.
All right.
That was the point.
Point towards it, that there were other calls that were not any problem.
All right, thank you very much. All right, the exhibit is proposed by the people is hereby admitted. You may continue, Mr. Aaron.
Your Honor, if I may, at this time, we'd like to play the
Sure.
the two.
Do you have a computer over there?
We have the names of playing here. Or?
Yep. Samantha will take care of it.
And as we're playing it, the first file, which is it's going to be an audio file. Can you tell us when that audio file was recorded?
It was recorded on June 25th at 11:02 a.m.
How long is it? Approximately a minute.
Yes. Not sure how long the message was.
Just prepare the court for it.
Oh, like a
Well, it's only a minute long.
It's a short one.
You may publish.
My legal name is Aaron Seibel. I am calling about the pro-pedophile prosecuting attorney in your office that seems to not want to press charges for sexual abuse. I need to be contacted at 231-201-0204. I will light a fire under your fucking ass all the way to state capital if you don't call me back within this day. Do you understand me? This has been a case that you need to prosecute. And I don't understand why you haven't filed any charges, why you haven't contacted me when you have my information. Again, my number is 231-201-0204. I will fucking county. I will be there for the rest of my life, making sure you don't go in the office ever again. Do you understand me? This is personal. You call me back today.
Thank you. Now, with regard to the second file, can you tell us when that was recorded?
That was on August 3rd at 3:24 p.m.
And that is a video file of
our
Mr.
office.
Seibel coming to your office.
Correct.
Now, prior to him coming to your office, did you have any advance notice that he was coming?
Yes, Detective Edwards from the Missaukee County Sheriff's Department called me at 1:40 and said that he had received a phone call from Mr. Seibel. He was very angry. He was very frustrated with our office and that he was on his way into the office and that we should be aware. And that if we had any problems to hit our panic buttons or to call law enforcement, and they would be on standby.
And published the second file, Your Honor.
You may
There
publish.
is no audio on this. I'm going to ask you to narrate it. And we're going to, as we start, I'm going to ask you the question, just like your
Okay.
position to provide the. There's a partition of glass. This is Mr. Seibel coming in. Are you on the other side of that glass?
Yes,
And you're able to listen to everything that's being said here?
correct.
What is he saying?
He's telling me who he was, that he had called me 3 times earlier and I did not reply to him, and he wanted to know why. I explained that we had our victim advocate had already spoke to him multiple times. We had given him a copy of the report from the incident in question and a copy of the declination letter, and that the prosecutor did not see anything conducive in meeting again, that he was told why the charges were not going forward, and we had given him the information. And I did also give him another copy of the declination letter.
You describe the tone of his voice.
At the beginning, he was calm and he was pleasant, and then he got very upset and he started yelling and being very loud. He had a very threatening tone to his voice. He ended up pounding his fingers on the counter. He yelled at me, and he was so loud and so threatening that 2 people in our office, both the prosecutor and the child support specialist, did hit their panic button to get law enforcement over to our office. He was very upset with me because I would not let him speak to the prosecutor. And that is where he is telling me that he asked if I had grandchildren and asked me some personal questions and if I would be the same way. And I again explained that the prosecutor had reviewed, we had actually 2 prosecutors review the file, and there was not enough information to go forward. And that's where he is pounding his finger, demanding to see the prosecutor. And then he turns around and he comes back up and he calls the prosecutor a coward and a pussy. And he goes to leave and he comes back in and he screams and yells the same thing. That prosecutor is a coward and a pussy.
With respect to the audio tape, did you hear that tape after it was recorded? Did you listen to it yourself?
The first one?
Correct.
Yes. I was the one who, it was left in my voicemail.
How did you feel after you listened?
I was worried that he seemed like he was very upset and that he would come into our office at some point.
Did you report it to anyone?
Yes, I had the prosecutor and the assistant prosecutor listen to the voicemail so that they were aware.
After he came into the office person, how did you feel?
I was worried that he would be waiting outside the office, waiting for us to leave that night. We did some proactive things. We did park in different parking spaces. We were afraid that he was waiting for us.
Thank you. Mr. Hartel?
Just a few questions. To confirm, based on what you were saying, my client didn't specifically say that he'd be waiting for you in your vehicle or anything specific like that, did he?
No, he was so mad, but he had made the comment before that he would make sure that the prosecutor did not come back into the office.
But nothing about preventing people from leaving.
Correct.
And I know it was stipulated to a moment ago, but to confirm, there were other phone calls before the recorded phone call we just listened to from my client?
That was the first phone call that he had left.
So-
And then there was one after it the same day. And then there was 3 of them the day that he came into the office. And I believe he had talked, and I don't have the dates, he had talked with the victim advocate, and she had spoke to him multiple times, told and sent him a copy of the report and the declination letter, explained to him why the decision was made not to go forward.
So to confirm, there were other phone calls where he indicated with members of, I'll say your staff, where it wasn't threatening. Am I understanding that correctly?
I'm not sure how I believe probably the first one, but I don't know exactly what the conversations were, just that he had called. Because when we got the message, when I got it, the victim advocate said, "Oh, I have talked to him. I have given him a copy of the report. I gave him a copy of the declination letter, and I explained to him why this happened, and he was very upset."
I believe you've answered the questions that I had.
Nothing further.
Mr. Stapleton, we can take that down. I've already seen the video. Thank you.
Yes.
And go ahead and pull out from the cord, the HDMI cable. Thank you.
People have no further witnesses.
Mr. Hart, sorry. Gordon, you're free to step down now. Thank you. I forgot. Could have just left you there. All right, thank you. Mr. Oh, wait, the government president, Mr. Hartel, the floor is now yours.
Yes, Your Honor. My client would wish to waive his Fifth Amendment rights, restricted just this matter. He would wish to testify on his own behalf.
Okay, now we are fully aware of doing it. Okay, now I want to be very cautious. I'm going to turn to Mr. Seibel. All right, Mr. Seibel, any statement you make, as Mr. Hartel referenced a little bit there by talking about Fifth Amendment rights, could be used against you in either this matter or other matters. Okay, and I'm not here at all to dissuade, nor would I, and nor do I want to dissuade you from talking or testifying at all. But I need to also ensure that you understand what the potential risks are. Now, this court is a neutral officer. I'm not in charge of filing charges. I'm not in charge of making plea agreements. I'm only in charge of accepting pleas, issuing sentences, and monitoring a trial. And in other words, affording any party or either party due process. Now, I have some familiarity with these cases. Let me read a definition. Mr. Hartel, if you have inside your drawers there, you should have some books.
Yes, sir.
All right. Do you have a criminal jury instructions book? If so, do you have volume 3?
What's volume 1?
All right, tell me, yeah, there should be. Now, there were volumes 1 and 2, and then in 2025, they added a 3rd volume. So just tell me what the date is on the cover of the ones that you're holding up.
The one that's the most updated, the volume 2 is a November 2022 update.
Date that. Use volume 2022 and see if you can find model jury criminal instruction 38.4. Or the back of volume 2. And that's 38.4. Let me know when you find it. Mm-hmm.
38.4, Your Honor.
Okay. All right. Now, what I'm going to do is I'm going to paraphrase. I'm sorry, not going to paraphrase. I'm going to read the model jury instruction. Now, the model jury instruction is not the same thing as the statute, but it's based upon the statute. And specifically, it would be MCL 750.543B. All right. To require, a jury to be able to find a defendant guilty of a terroristic threat. Now, I don't know. The prosecutor he might not be the one to charge it because he would have a potential conflict, but it could be referred out to a prosecuting association or the Attorney General's office for the appointment of a non-conflicted prosecutor. And if it were, and I have no control over the list, and I have no opinion as to whether or not it should. All right, good. So I'm just trying to make sure you understand my role. If you look toward the middle, it says to prove the defendant threatened to commit an act of terrorism, the prosecutor must prove, number 1, that the defendant communicated that he would commit a felony crime. I heard the phrase, light a fire under your butt or your ass or something to that effect, and it continued to be arguably assaultive or violent. Next, it says that the defendant knew or had a reason to know that committing the felony would be dangerous to human life, meaning that committing the felony could cause a substantial likelihood of death or serious injury. Now, here's the next part. That by committing the felony, the defendant would intend to intimidate, frighten, or coerce a civilian population. Well, that's not applicable. Or, and here this is important, or influence or affect the conduct of government or a unit of government through intimidation and or coercion. So my point is, whenever a case is brought, the initial question is there probable cause? So if a prosecutor were to charge making a terroristic threat, it would start out with the determination by a district court of whether or not there is or is not probable cause. Now, that is one of the lowest standards of burden of proof. And we know that the highest burden of proof in the United States and here in Michigan is for a criminal trial, it's proof beyond a reasonable doubt. So therefore, I'm not making a statement as to whether or not there is or isn't probable cause, or if there is or wasn't proof beyond a reasonable doubt. You just need to make sure that everybody has considered this. For instance, Mr. Hartel asked a question of Mr. Stapleton. Isn't it true that the report from Detective Edwards made some kind of conclusion? having no offense of Detective Edwards. This court isn't controlled by, no court is controlled by a law enforcement officer. We don't work for them, and they do not work for us, meaning the judges. We're more than willing to take a stand, and I, again, not going to dissuade you from that, but I just need to make sure that you understand. Now, I don't even have to go over your Miranda rights, because Miranda is only required when you are in custodial interrogation. Well, today you're not in custody, and this is not interrogation, it's testimony. But I also have a responsibility to ensure effective representation. And I'm not making a determination if Mr. Hartel is effective or is ineffective, but I suspect that not too many people have dealt with terroristic threats. I have gone to classes on them, deal with them with judges, and making a terroristic threat is a felony. And find out here which is the appropriate statute. I think it's MCL 750411H. Just a second here. Would be a felony punishable by up to 20 years, and it's a Class B felony, which is the second highest level underneath the guidelines. And I can tell you, not knowing anything about you, that almost even underneath the guidelines would likely result in a prison sentence. And you can testify, it's fully up to you. But for me, I always have to advise, any judge has to advise defendants of their right to testify and ensure they're making the decision on their own, freely, knowingly, and voluntarily. And that one word, understandingly, knowingly. Now, knowing means that I need to make sure that you heard what I just said. That's all.
I have
So, good enough. So do you need any time to talk to Mr. Hartel?
No.
All right, good enough. Thank you. All right, again, I'm just here as a neutral guy, making sure that everything's being done. All right, do you wish to testify?
I do.
All right, I'm just going to swear you in from there, but I'm going to have you come up here. All right, go ahead and raise your hand, sir. You swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may have a seat. The court takes judicial notice that this is the defendant, Mr. Aaron Seibel, and Mr. Hartel. The floor is yours. Thank you.
Sir, I know we got a few things to discuss here today. You were listening a moment ago to yourself on the phone in that recording, is that correct?
I was.
And do you remember what date that was from?
I don't remember the exact date, but it was, I'll agree, it was from 25th.
Okay,
Yeah.
fair enough. When you made that call, why did you make that call?
Well, I made that call shortly after I read the police report. It was the first time I read in detail the assault that took place with my daughter for 2 years in her own home. I was very livid. I was under a lot of anger. Upset the fact that the case had been sitting on the prosecutor's desk for a year and no charges had been filed. There had been no communication between me and the prosecutor's office, zero, other than giving me the police report. I was pretty upset that nothing had been done when there's a predator walking around this world that had molested my daughter. No one has done anything about it, nor communicated why that was not the case with me.
Confirmed. You're saying when you made that call, it did after approximately a year from receiving that report. Did I hear you correctly?
I received the report that day.
Okay. You mentioned something about a year. What was going on for that year?
So when I pressed charges a year prior, I thought the charges had been filed. There's a guy going to jail now. The process is taking its place. The system supposed to do its job. I advocate for my daughter. I advocate for people who are in need, and then people who advocate go to the prosecutor's office, go to whatever office is deemed necessary or appropriate, and then they in turn do their job and do the investigation, which the sheriff's department did a great job, and then provided that to the prosecutor's office, and then they just sat on it for a year and have done nothing.
I don't want to make any assumptions. I also obviously listened to that. What was your emotional state of mind while that was going on, while you're making the phone call?
One, I was feeling inadequate as a person, as a father, being unable to protect my daughter. Two, I was thinking, how can I make sure this prosecutor never holds office again? And that is for me to bring about attention to this case, which when I said fired under your ass, I didn't literally mean, Your Honor, put a fire under his ass. I meant fire under his ass, like I'm going to picket, I'm going to publicly gather support for this. So you will do your job and either A, tell me what's going on, communicate with me, because I'm the father. You know, I may not have been around then, but I do deserve to be around. So when I say fire under your ass, I say, hey, do your job. I'm going to cause attention to this. So you're not sitting around, not doing anything. I need to be communicated to. I deserve that. I have been doing everything I'm supposed to be doing. So please communicate your decisions to me. And I have yet to receive any letter, as you saw in the video that was given. Gave me 2 pieces of paper. As you see in the video, I only got 1. And that was an email that they gave the sheriff's department, stating that they're not going to continue the case at all. I never got a reason why, still haven't got a reason why. I've called the prosecutor's office multiple times. I've apologized for that call I made because I was extremely upset. I know that that call probably didn't open the best avenue of communication between us, but still, I apologized afterwards. I said I was sorry, I was angry, upset. Don't know quite what to do other than try to keep advocating.
And we'll talk more about a few of those things. I'm sure there'll be some cross-examination as well, possible some questions from the court in a moment. But circle back a little bit. You mentioned the fire part, but the picketing part, when you say that, were you envisioning anything other than just the usual freedom of speech type picket? Were you alleging any threats, anything like that?
No, I mean, not go to the office. I mean, like, not go to the office. You're not going to hold office after this. Like, you're not going to be elected in because I'm going to make all your heirs aware that the things you're doing, just like the Chad Hickman shooting, you know, he was also he had charges of first degree CSE, and he went and killed, including himself, 6 people when he had child sexual charges on him. He is also a child predator from what was written, and that office was soft on that case and only charged him with the 4th degree child abuse. When
Just for a clean record, though, Mr. Hickman's situation was after your phone call, correct?
yes, it was
So I just want to make sure we had a clear record. I'm not saying one thing or another. When you were in person, you were watching that video as well, correct? It's not up there right now, pointing to where it was, but you were watching that with me a minute ago. All right. So tell us we heard from the witness what she remembers being said and exchanged. What do you remember being said and exchanged?
I remember coming in there, and honestly, I called the sheriff's department hoping that they would open the bridge of communication between me and the prosecutor's office. And I wholeheartedly apologize if I came up threatening to you. That is not my case at all. I thought that Nate Edwards would call you guys, which he did, which he said he did. And then when I went there, I thought this dialogue would be opened up, that I can go there and I can get 5 minutes of prosecutor's time. Someone's time can tell me what is going on with this case. Nobody has told me anything that's going on with the case. I still don't know why that the prosecutor's office is not prosecuting this case. I have no idea. The evidence is clear. I don't know. I'm upset.
I might ask you some more pointed questions as well. When it came to, I know we heard some testimony about asking people about if they have grandkids, things like that. To be clear, were you trying to threaten anybody's family?
No, I simply told you. I said, hey, I asked you, hey, if this is
No,
yours.
to her directly, please.
All right. I asked her if it was her kids or her grandkids had been molested for years on end, you would be right here on this side of the glass with me, angry and upset. You'd be right here screaming at the top of your lungs, and the prosecutor in the fucking back room who just sits there and hides back there. It doesn't have the balls to come up here and see me face to face. But why is he making these decisions and not talking to me when I'm standing here? I just drove 2 hours and I called up there. Hey, I'm coming. Please have the decency to come and speak to me in person.
So if I understand correctly, and I did notice some emotion right there, and I don't mean to make you relive everything, but was that the same emotion you were feeling at that time? It's okay, whatever the correct answer is.
Yeah, I can look. This is a hard one to distance myself.
If you take a moment, I'm sure the court will understand.
Yes, I was emotional.
Okay. And to be clear, even though you're emotional right now, you don't mean any ill will to anyone in this room, do you?
No, I never meant any ill will at all.
All right.
Towards anyone.
All right. Including in those past interactions by phone or in person?
No, there was no ill will. It was a metaphor.
Okay. All right, sir. I believe you've answered my questions. The people or the court might have some more for you.
Donnie?
Your Honor,
Yes, sir.
I saw you getting pretty emotional as well. Is that pretty normal for you to get easily excitable and angry?
Well, when you imagine a man touching your child and molesting her, I would assume it's pretty normal for people to get upset. Yes, I would assume
Right.
that's a hard one for people to just to accept and be neutral on.
So you have anger management issues generally?
No, I don't. Not at all.
Remember meeting with Sheriff Deputy Nathaniel Edwards?
I do.
And an outburst in his waiting room. Remember that?
Define out first.
Raised your voice, started screaming. Remember that?
I didn't start screaming. No, I've escalated my voice. Yes, I am upset. with this
Did
whole
you tell
situation.
him that that's how you're trained to release your anger issues?
Oh, screaming. Yeah. So it's called scream therapy. Yeah.
So this
I
is
do
something
scream
you
therapy.
do on a regular basis?
Scream therapy. Yes, I do.
All right.
Yeah.
You understand that other people may not view that as normal. They may view that as someone intimidating. Especially if it's directed to somebody. You understand that?
Well, I explained myself immediately and what I was doing. Yeah.
Right. Only because he asked you to stop.
Well, you didn't ask me that. Anyways, we can continue that.
Now, when you went to the prosecutor's office, were you armed in any fashion?
Armed? No. No, I don't have any weapons at all.
You were arrested at the sheriff's office, is that correct?
That's correct.
And were some things that were confiscated from you, is that correct?
Whatever I have in my pocket.
What did you have in your pocket?
My wallet? Utility knife? Maybe?
Utility knife, could you please describe the utility knife?
So my utility knife is a Milwaukee utility knife I use daily for my work. I'm in the middle of renovating a building. I've used it probably the past 20 years of my life.
Is this a sharp object?
Yes, it is.
Cutting object?
I also have a pen on me too.
Is it a sharp and cutting object?
Yes, it is.
There's a razor blade on it?
There is no way to tell what it is. It's in my pocket.
You have it on you right now?
No, I don't, because they don't allow it in the courthouse.
Thank you. But it was confiscated, is that correct?
If it's on the paperwork, then yes.
It was also white powdery substance?
I'd object to relevance on this part, Your Honor.
I don't know where he's going with it, whether or not it's relevant.
Cross-examination.
Hold on, bro. Stop. I'm very stern, because it's the courtroom in which I am in charge. If I'm answering a question or a comment, I'm going to be the only one to talk, because I will ensure that when you all have the opportunity to talk, you will be the only one. The answer to the question is. Now, I don't know what its relevance is. As we know, underneath Fiscal Rule of Evidence 1101, when it comes to sentencing matters, which include probationary sentence issues, the sentencing, rules of evidence do not necessarily apply. Now, I don't know where he's going. He might have more evidence. For instance, arguably, let's assume that he's going to some issue that involved a controlled substance. Maybe if, I don't know how many cases, by the way, so I don't know enough about it. But I can foresee, arguably, Mr. Seibel, I'm not picking on him, just
That's fine. No.
being a judge.
I appreciate it.
So, I don't know. Let's say, for example, the prosecutor's office had prosecuted him for drinking and driving at public show with drunkenness and in a small town, which I think he's from a different town. But let's say it's in Lake City where everybody knows everybody. They might be panicky because of repetitive intoxication. So when I look at, or when a witness looks at what somebody says and what they mean, might be based upon their prior experiences with that individual. Another example would be if a woman who is a victim of domestic violence and abuse repetitively has seen that the person gets abusive and violent, and she acquiesces or is interpreting a situation based upon her prior experiences, there might be more to it. So I've just given a way too extensive of an explanation, but I'm going to overrule the objection. And Mr. Hartel, now that, of course, one of the things is if I've given that much of an explanation, I've already helped Mr. Heine fashion his argument. Not about you fashion yours, because you might say, Judge, it wasn't relevant because they don't have any involvement with Mr. Seibel. That makes sense? It does. All right, good enough. Whew. Mr. Heine, you may continue.
Just like where I'm coming from, Your Honor, it may provide an explanation in cited state.
I got it. You just go right ahead.
Were you under the influence of any drugs when you went to visit the prosecutor's office?
Definitely not.
Sorry?
No, it was definitely not. In fact, I had a drug test like a few hours later that day.
Was some white powder found on either on your person or in your car? Is that correct?
No, I didn't have my car or never found anything on me. First time hearing about it right now and reading on the screen. I have no information about this at all.
So it might have been in the car, but the car didn't belong to you. Is that correct?
Not my car.
The car wasn't.
Do I have to answer that?
Right.
I mean, where are we going with this? This is just, what is a car?
I'm just not sure if this part's relevant.
If it wasn't your car.
Hold on.
This is a public.
Just take a minute, Mr. Seibel.
By the way, that was the suggested response at our judicial conference this past weekend. Take a moment, relax, walk away. I'm in charge of the check question and the answers. And when a witness is on the stand, they answer the questions that are asked and do not argue. And Mr. Hartel has demonstrated already well, not only here today, but many times in front of me. He knows when to make an objection. So just answer the question. If it's not relevant, Mr. Hartel will object.
Got it. Sorry.
All right, that's okay. I understand. Go ahead, Mr. Heine.
You said it wasn't your vehicle?
It's not my vehicle. It's a friend's car. It was a friend's vehicle.
Friend's car.
Yes.
You have permission to drive that car?
Yes, it did.
No further questions.
All right, thank you very much. It ended up going almost nowhere. All right, Mr.
I do
Hartel,
believe I have some relevant questions.
go right ahead.
Sure.
Yes.
So to confirm, sir, I believe you mentioned utility knife, as we're phrasing it, is a commercial thing used for your work.
I use it for my work every day, yes. I'm a builder, handyman of sorts. You know, I use it that day. It goes on me from next pair of pants to next pair of pants. It's just part of my being. It's an extension of my hand, honestly.
To confirm, I don't believe there's any testimony to the contrary, but you weren't brandishing it or even making it aware to anyone before it was
No,
found.
all it looks like is just like this. It looks like that. And this is a wallet. So it's impossible to know what it is unless I were to.
Just so we have a written record where you're pointing to stuff, was it your pants you're pointing to for the?
Yes.
Okay.
Yeah.
Because the
it's-
record can't necessarily see what you're pointing.
Yeah, to me, it's a tool, not a weapon.
So no intent, and no one even knew you had it.
It's also a screwdriver and at one end too.
All right. And I believe you already answered this question, but just to confirm, you were given a drug test, correct?
I was.
And to your knowledge, did that come up positive for literally any?
Came positive for the medication that I'm on. That's it.
Okay, so nothing illicit, nothing.
Nothing illegal at all.
All right. I believe you've answered the only question that would be appropriate for me to ask on request.
Thank you. Anything further? Mr.
Nothing. Further.
Thank you. Mr. Sabo, you may return to your seat. Thank you. Mr. Hartel, any evidence, anything further to produce?
No further future on that.
All right, thank you. All right, anything in rebuttal, Mr. Ion?
No additional cases, Your Honor.
All right, thank you. Closing argument, sir?
At this point, Your Honor, we would ask that the court find the defendant as having violated conditions of his probation, given that he not engage in threatening and intimidating behavior. The phone call in question would be intimidating to any reasonable person. Similarly, visit to the prosecutor's office for whatever good motive or reason or explanation he may have in his mind. What could a reasonable and objective person be viewed as threatening and intimidating? Raising his voice, pounding, and you can see he's basically spit out a wad of gum. Raises a level of threatening and intimidating behavior. So we would ask the court to find him guilty of violation.
Mr. Hartel?
Yes, Your Honor. I asked the court not to find my client guilty of the violation. We can see why there'd be reasons for concern, but my client did testify, provide explanations for his state of mind, for his actions. I don't believe he had any ill intent. I don't believe that he was trying to intimidate or threaten anyone. I believe that he explained why some of the turns of phrase may have been potentially misconceived, but I do believe he explained that as well. I know it's not the only thing the court has to factor in, but Detective Edwards, at least in the report, did note that he didn't believe that there was any assaults or threats being made. If I remember correctly, I know I closed my laptop at this point, so I'm not looking directly at the report. And based on the fact of everything we've heard today, including how much time was spent with the prosecutor's office before that, explanations of the frustrations, I'll phrase it that way, as well as the fact that we stipulated there was other non-threatening communications, and the fact that he then went to the police where he was arrested. He obviously, I use the term obviously, but in my opinion, as a defense attorney, wasn't then trying to escalate anything. He was like, here I am. He cooperated, obeyed the terms of probation, submitted to the drug test, all those things. He explained why he might have had a tool on him. There was no testimony to any use of that tool in a negative fashion. If there is a finding, I'll make further allocution for sentencing, but I don't believe there should be a finding. Thank you.
All right, thank you. All right, folks, this is a very complicated issue that may not seem to be complicated, depending upon where you sit in this courtroom. There, or here. Unfortunately, in today's world, well, and I'm intentionally saying the word well and pausing so I can go back and actually say this. It's not just today's world. It's always been this way. Humankind always acts and justifies their actions. It used to be the rattling of pitchforks and torches outside of a castle gate, or a variety. And just today's world, it's the same thing, but instead of pitchforks and torches, we now have media, which is horrible. Now, everybody has the right in the United States for the right to free speech. Now, not everybody understands entirely what constitutional rights mean. For instance, constitutional rights, at least handed down by the Supreme Court for the U.S. and the state of Michigan, say that some are absolute. The rest are fundamental. Not too many people who actually study the law, if they actually do, might even understand them. Absolute. You have the absolute right to believe any religion you wish to choose. Exercise your right. Now, there can be limitations because it's fundamental. For instance, if you're in a prison and your faith, you believe, allows you to have candles and a black cloak, it can limit that. Why? Because there is a legitimate governmental interest, and they can do it to the least restrictive means necessary that still allows the person to exercise that right. So again, free speech is, just like any of the others, more of a fundamental than an absolute. Now, not everybody understands that. I've dealt with it recently. I know somebody is, people who tell me when it's on Facebook, most people in my household and my family and my friends know, don't ever tell me. I don't really care a whole lot, because people have the right for free speech, and I champion that as a judge. Now, what they don't have is a right to speech that incites violence. For example, If a person wishes to say that all people who commit certain crimes, such as they're pedophiles, they should be killed. That's free speech. But at least my interpretation is that when they start yelling and chanting and show pictures of people and say, this is a guy we could kill, now you've gone too long. Now, you didn't do that, Mr. Sengel. I'm trying to use examples that don't necessarily apply to this particular instance, okay? So I start off with that. Do you have a right to go and demand to be heard and seen by the, or say in protest outside? Yeah. Right. Nothing wrong with it. That's great. Now, you do have some rights here. I didn't ask you any questions about your daughter because it's not necessarily relevant, but I think I can conclude that she was under the age of 18. Thank you. Now, that tells me that you have the right underneath the Victims' Rights Act as a parent to reach and receive information. Okay? So there's nothing wrong with you going to the prosecutor's office and asking to be heard and have the right to communicate. That's what the Victims' Rights Act requires. Prosecutors don't, by the way, have to do what a victim or a victim's family member says. For instance, before a pretrial agreement or a plea is entered pursuant to a pretrial agreement, the prosecutor in a victim's rights case must go to the victim. And if she's under a certain age, that means those who have custodial guardianship over her, such as a parent. Then they have to go and say, all right, this is what I'm doing and why. They don't have to take it. They don't have to do what the victim says, but they have the responsibility because we actually have constitutional rights in Michigan regarding the Victims' Rights Act to be able to be told. So far, the source of what you were doing, thinking and feeling, yeah, you've got a right to ask those questions. Now, when it comes to cases, what I've often seen, and I wish I could talk to people on social media, I've written articles and talked about it, but it would be this. Don't go sharing stupid stuff on social media unless you know what you're talking about. Now, I'm not saying you don't. Bear with me. Hopefully with everything else I've done and said today, you understand that I've got a long reason for explaining it. Because I have the obligation to. Criminal cases, you used a word earlier, a phrase, the criminal justice system. I wish more people understood what that means. Well, just like our government, we're not going to get into whether or not we all agree with what goes on in Washington, D.C., but the criminal justice system is operated by human beings. Means it's not going to be perfect. And in our system of government, it's got balances. The executive branch, which is the prosecutor's office and the law enforcement office, and the Department of Justice, which is Mr. Stapleton's province, have no control over me. I have no control over them. So when they cut a deal or negotiate a case, as long as the defendant comes in and admits to the facts that are required, I have to accept it. I don't get to say, well, I don't like that deal. That's stupid. I don't get to do that. I only get to exercise my discretion, really, when it comes to sentencing. So I don't get to tell the prosecutor's office whether or not they made the right deal or should have cut a better deal. Same thing, other branch here. It's not really a branch, but you have the right to ensure due process between these two branches. And that's why you have the defense attorney, which, by the way, for anybody who studies constitutional law, is such an important part of our government, even though it doesn't, well, technically get paid by the government. It's one of the only jobs mentioned in the Bill of Rights, the defense attorney. Sixth Amendment. So, we have due process, and that's a key thing. Now, another thing that most people never consider is that branch over there, which is why he is here and I am up here, because charges mean absolutely nothing. They don't have any proof yet. They are just an allegation. So when somebody takes a look at a charge and says, well, this person was charged with A, B, and C, I don't care. And we have a very good example of that today. I'm not telling them to do it, and it's already been handled. Had I been them, I would have charged you with violating Rule 1 for making a terroristic threat. They didn't. That's their discretion. Just like whatever they charge this person that we're talking about, and I don't need to know that other defendant or suspected defendant, whatever, the other suspect. No matter what the allegations are, it doesn't mean anything until it gets to the trial phase or a plea phase. Now, another thing that people rarely understand, and I have a great deal of sympathy for you in this situation. You talked about why you need to carry the knife. I got it. So clearly you're not a lawyer. By the way, I don't carry a knife, but I don't use any tools because I don't know how to use any. I somehow have 4 hammers on a tool bench. I've never bought one. I have no idea where they came from. I don't use it. I don't even own a lawnmower. Thank God. So let me tell you this about law. Charges are just charges. It takes proof. Proof is in the form of evidence and physical evidence, and evidence can be also testimony. Now, when a prosecutor is over there trying to make a decision, that prosecutor, and I'm not making any comments about any prosecutor involved in this case, they may not be that good. So yeah, if you want to protest and help get somebody replaced, that's your right to go out and do so. And I encourage everybody to appropriately exercise their right to free speech. And I'm not saying anything about Mr. Denham. They may not be. I used to be a defense attorney. I've been a defense attorney a lot longer than I've been a judge or a prosecutor added together. And some of the defense attorneys have no clue what they're doing, but some do. And some really are good at picking apart defenses, or prosecution. So I don't know. But I also will tell you the most difficult kinds of cases, besides embezzlement cases. Embezzlement cases are hard. Why? Because most people don't even know how to balance a checkbook, let alone track the stealing of money from a business. And whoo, those are difficult. Murder cases. Is there a body? Yes. Is there a gun or a knife with fingerprints? Is there a motive? And is there an admission? It's pretty easy. They draw the most drama, take the longest, but they're not that difficult. Assault cases, especially with young people, are extremely difficult. Now, I don't know anything about this case. And as a judge, I bet one of the best parts about being me is I no one ever asks me, Jason, what's going on with that case? Because I don't know. Oh, it's so nice to be in the circuit court judge. I don't know what's going on with any case until it comes in front of me for trial. So let me say this. Sexual assault cases. Most of the victim comes from the young person. I've had cases when I was a prosecutor and the young person who's the victim has come to me without mom and dad present or asked to meet with me and mom and dad left. And she cried in front of me and said, I can't testify. And I can't tell mom and dad what the truth said. I don't know. I'll also tell you this. If you've ever sat here and witnessed and saw a sexual assault trial with a young person, the jury might make the decision on did she cry enough or did she not cry enough? She might not have cried enough because she's got great parents that help take care of her and counselors that help her. She may not cry enough because she's lying. The point is when a young person is on the stand and the jury makes a verdict and that young person leaves, feels that they don't believe her, there's a lot that goes on to making those decisions. Now, there's another thing regarding cases like this. This meaning the sexual assault case, and again, knowing nothing else about it. We all know that when we come up on a body, because we've seen it all on TV, because that's all we like to watch, apparently. See a body, we see blood, and we see a knife, we know don't pick up the knife. We don't want to contaminate the integrity of that evidence. We have forensics that tells us how to do it. We do the same thing with computers and cell phones. You don't want Jason Elmore going into a laptop trying to figure out where the hidden information is. I will destroy the computer. I have no idea what I'm doing. I unfortunately somehow delete my kids and my family from the Life 360 thing because I hit the wrong button and I don't know what I did. That's why we take computers to forensic scientists to determine is the information on there and extract it out in a certain way. And the same example here involves children. I don't know anything about it. But the information inside of a child's head, especially if they're under the age of 12 and 10, somewhere under them, I'll extract that information the right way. And I don't know anything about this. Now, Detective Edwards generally does the right thing. He knows to get the young person to the Child Advocacy Center to have a child forensic interview. Because if they don't, I've had cases as a prosecutor where the only person that did all the interviewing was the mom, and there was a divorce going on. And they contaminate the information inside the child. So the only point I'm trying to make is charges mean nothing. Evidence only means something if you know how it can be applied. Now, here's the thing. I talked about how knowing how it can be applied. Is it admissible? Is it relevant? I have to determine the law as a judge. Yes, it can be presented. No, it can't be presented. And there are reasons and the rules of evidence. By the way, the rules of evidence are an entire semester college class or law school class. It's probably about $10,000 to take it. Anyways, so when we make decisions about when prosecutors make decisions or defense attorneys make recommendations or judges do, people have absolutely every right to be heard and to speak their mind. Often people do it very sloppily and have no idea what they're talking about. The other thing, though, is here's why I started earlier with the Victims' Rights Act. There are lots of reasons why it exists, and one of them is exactly what I said. So you can go ask the parent and find out. That's why they have to talk to you and share information. It's not so that there's nothing that says prosecutors go out there and tell the world on social media why you did or didn't do something. But the victim or the victim's parents have the right to be heard. Sometimes prosecutors don't do it well. There's another there's a law called malfeasance and nonfeasance, which is where you try to get a prosecutor or a public official, maybe it's a township commissioner, for not doing their job right. Okay. There can be things called writs of mandamus. I'm not going to go explain them. I think here what happened is you didn't know why or what the decision was. Now, I take it you don't have full custody, but maybe there's a mother that does. She's 19 of a daughter is. Yeah. So anyways, I don't know what the situation was at the time. Maybe they talked to her. I've got no idea. So I'm going to say that the fact that you went there, I understand. The fact that you made the call, I completely understand. In the method of how you did it, that's the difficulty. I'm taking this long time to explain this, not merely to hear myself talk, but because I don't know anything else about you. I remember there was a child support case, right? Got it. That has nothing to do with this case other than the fact that's why you're on probation. You were concerned, you wanted information, and you didn't feel you were getting it. By the way, Ms. Morgan isn't the elected official. She's a county official, but she's not elected. Elected person is prosecutor. Now, this frustration, I don't know much more about it. I don't have a prosecutor here telling me why he did or didn't talk to you or did or didn't have enough time on a particular day. Circle back to pitchforks and torches. Everybody thinks these days that it's okay. I had a case last year up in a different county. I had to cover it because somebody decided, because he had read something on Facebook, And he never had a case in front of this judge. I don't even think he had a prior criminal charge. He was in the 60s. He called and left a voicemail message, 2 or 3 of them. And Facebook. This judge needs to be hung. It needs to be this and this and that. Remember, I told you that anybody saying, well, all pedophiles should have this happen. Okay. But when you start saying, hey, we need to go kill this particular one, that's what his comments were. Silly. He had never met, he was complaining about what he had read from a mother regarding child custody. He'd never met her. He had never even been to Kalkaska, where the case was being held. He sure as heck felt, because he was one of those Facebook freak, people following it, decided that was the right thing to do. He's now in prison. Jury found him guilty. Prison for 2 years because he decided to champion a cause that had nothing to do with him on Facebook. This has something to do with you, so I can understand why. I understand it because I've been in Mr. Hartel's spot, and I understand it because I've been in Mr. Ani's spot. How frustrating it can be. I've got 3 children, and one of them was a daughter, and she is, no offense to my boys, extremely special. They're all special, but let's just be honest. All right, so now, when a court makes a ruling, I have to do it based upon, I take the nuggets and I put them in the elements of proof. Then I apply my real discretion when I come to the sentencing portion. So now there's a case that came out a couple of years ago. It was actually 2 years ago. I want to make sure I get the reference correct. It actually talked about how the statute that we're talking about, MCL 750.543B, is unconstitutional the way it was written. And Nancy, I'm going to spell this for you. People versus, and I'm going to botch how I say it, Nasiska, KVASNICKA. Again, it's KVASNICKA. Now, if you were somebody who was excited about reading it, you would go to Michigan Supreme Court. Hold on, my computer's moving slow. Actually, it doesn't have a Michigan case number, but it is Supreme Court case 168181, and it's reported at 18 Northwest 3rd 308. Came out in 2025. So where there might be some issues with its constitutionality, that doesn't require proof that the person actually intended. Right? I'll give you an example. Assault and battery. Battery is when I actually touch somebody, an offensive or harmful touch, like a punch or even a tickle. I know Sam, but I don't know her well enough that I would ever tickle her nose. But if I did, it would be offensive. That's a battery. An assault is when Sam feels the threat of an immediate offensive, harmful touching, an immediate battery. If I see it in front of her, I don't actually tend to do it. I say, oh, Sam, you upset me. I'm going to kick your tail in. I'm going to punch you in the face. Inside, I'm thinking, I'm not really going to do it, but I just want to scare her. Happens in domestic violence cases all the time. You don't have to prove intent. You just have to prove, did the person commit an act that would make a reasonable person feel or fear or sense? In our world today, unfortunately, we've got way too many people who like to make threats and comments and statements. And while you may not have intended to, if the person who was on the phone received it. By the way, I've received them. I used to get them all the time as a prosecutor. Domestic violence victims telling me how horrible I am prosecuting their lover, even though they've been convicted 5 different times, and she keeps going to the hospital. And I would tell her, yeah, I don't care. I'm still going to prosecute your husband. Screaming. I got used, at least I think I got pretty used to comedy. But do I think you're guilty of this? Yes. Therefore, I find you guilty of counts 1 and 2. Now, the next point, however, is the sentencing portion. And that's where a judge really gets to apply his discretion. I've talked way too long. Recommendation, Mr. Stapleton?
Thank you, Your Honor. Original sentencing guidelines, 5 to 28 months. The defendant has 60 days credit as of today.
Did he have any jail a part of this? Like, I don't think did I order him arrested? He did, didn't he?
Pardon?
The question was, did he get arrested on this? I issued a bench warrant, right?
Yes, he did.
So the time includes more than what he got at the sentencing earlier this year. In other words, he's already served a couple extra days.
Yes.
Correct? Bingo. Keep
Yes.
going.
The nation I have is, Your Honor, 75 days jail with 60 days credit. Whether or not to continue probation, I believe the defendant can benefit from additional resources of probation. So it's up to the court whether or not we want to continue probation or not. He has,
How many months does he have left?
he was sentenced to, I believe, let me see, it was 2 years probation in March of this year.
Copy.
So it's pretty early on.
Thank you. Keep going.
That's all I have, Your Honor.
All right, Mr. Ani,
We would just support it.
Mr. Hartel.
Yes, Your Honor. I'd ask the court to allow my client to prove that he completed probation successfully. For what it's worth, I realize the court could sentence him either to the recommended amount or perhaps even more. I know he'll want to make a statement about his employment here in a minute.
I'm going to suggest that you don't have to say a whole lot.
Okay. What I will stress to the court is he does have productive things he wants to get back to. He has big events that his employment is related to, and he has every desire to be productive and to catch up on child support.
All right. Mr. Civil? Civil or Seibel?
Silent.
I'm sorry. Go ahead, Mr. Seibel. Anything you wish for me to hear?
I have a big court hearing on the 24th. It determines pretty much the biggest point of my professional life here in Michigan.
Okay.
It's 24th, it's Elmore, business and immigrant.
Okay.
Um,
Prior criminal history?
I have some when I was 17.
Okay.
Then
Mr. Stapleton, may I see the original PSM?
Yes, sir.
You don't need to talk about that. Go ahead. Anything else?
I since I've been in Michigan, I bought a house. I have school. It's downtown Grand Rapids storefront. I'm renovating now. I'm a host for Art Prize. It's a big art in downtown.
I'm well aware. Yes.
I've maintained monthly payments on child support. I haven't missed any. Paid all the court costs here. That's doing everything possible to achieve success in my life that I'm trying to achieve. Recently attended a business conference. Big project
Looks like you're 41.
for one. Way to
All right.
I'm doing good things.
All right. Thank you. All right, Mr. Seibel, I do see that you've had some prior history. And the thing that concerns me really the most is some of it has been assault. Now, you referenced, for example, that one case that everyone's usually chatting about on social media. I'm not going to talk about that file, but other than to say this, there are cases here, instances, even about 10 years ago, right, it's 10 years ago, that involved acts of domestic violence or yeah, there was a trespass in 2009, malicious destruction of property in 2006.
I don't drink anymore, Your Honor.
I got it. So hold on. Let me explain it. And I generally, by the way, look to see where people's drug histories and alcohol histories were at the time. So I have that concern. So what happens is, let's say, and I don't think you're going to, He went out on a spree, very similar to what we've heard about. Imagine right now if somebody only read the black and white and then they looked at the prior history. And if Judge Elmore didn't give something, oh my gosh. Now what happens here is maybe those people wouldn't pay attention and heard all the facts that I've heard today. It wouldn't give you the tenderness or sympathy or empathy, whatever. I always put those two words mixed up, but what do I do? Now, say you were the type who did carry firearms. Now, by the way, you can't because you could felony convictions, but and you went out. If I were Miss Morgan, I'd be scared. I know you've said the right thing today. My family gets it all the time. We've had to be escorted out of restaurants because of people staring at us, videotaping us. Looking at me. Things happen. So, but here today, hopefully I've explained it. I kind of understand what happened, but it's that switch. We all can have it. By the way, it trips when it normally involves children. I don't blame him. I want to know.
5 minutes.
I got it. I understand. So I'm civil, sorry. I understand why. I do. But I'm concerned about the prior acts. Now I know you're not consuming, but why do you think that occurred? Why do you think your switch went? I mean, the firing under asses and protesting. I don't care about protesting. That's fine. Go ahead and do it. Sorry. What I meant is, if you're going to do something, do that. I'm not trying to say protest, Mr. Denham. I don't particularly care. But you think, what did you feel at that moment that it hurt?
I felt strong political motivations of not lighting any physical fire, but just picketing and advocating for my daughter, not getting people together and
And you wanted an answer.
I wanted to hold signs and let people know, like, hey, you're not doing his job and we're not getting an answer to this. I think people should hold their officials more accountable.
Yeah. Don't remember exactly the case, but when I was a prosecutor the first year, I didn't do a very good job explaining it to someone to a family. And then later on created not a class, but I would go certain things I would say and letters I would give out to make sure that I did. Whether or not Mr. Denham wants to do that, it's up to him. But that's what I did. So I realized I didn't do it right once. Felt horrible about it. All right. So the sentence of the court is the court preserves all fines and costs. The court continues the period of probation as previously set by this court. I could increase that period of probation, but he already had a delay of sentence for a year. And I think it's equitable for me to consider that as a third year in effect of probation, because now he's got 2. So now I'm explaining why I'm not going to extend probation. I'm going to continue probation. Are all the restitution and child support hasn't been caught up, am I right? So I'm going to keep the period of probation for that reason. And I'm concerned about anger management or control. And Mr. Stapleton can present to me an additional recommendation that if it's not already in there, for any kind of treatment for anger management. I don't want to ignore that. I think that would be inappropriate. We don't have any evidence of use of controlled substances or alcohol, right, Mr. Stapleton?
Oh, we don't, no.
Great, that's good. I'm really glad to hear that. We have had those prior issues in the past, and I'm quite concerned. So, one moment. The days of credit, do those include good conduct time?
Yes, that does include good conduct.
Okay. Okay. So when people champion causes on social media, sometimes the judge sits there and goes, ooh, I nailed a guy because I'm going to have to make a decision based on every case. I don't think you're going to go out and hurt anybody. I sure as hell hope you're not. Are you? No. All right. Do you understand why Miss Morgan felt frightened?
Yeah, actually, when she said that, I didn't just sit there putting their cars into the spots. I felt really awful for that because I did not want to drink through any of his life.
Court's going to sentence you to 60 days with 60 days of credit. Sometimes judges have to make decisions, and sometimes we're proven correct. Sometimes we are not. In this instance, I'm going to hope that I'm proven correct. Am I?
Yes.
All right. By the way, sometimes judges use these opportunities to lecture. Now I lectured a lot today. Well, I also did it to be able to not scare you. Sometimes you got to hear the reasoning. Miss Samantha's going to give the prosecutor or defense attorney 2 copies of one document. You're going to sign it. 1 copy. Doing so only acknowledges receipt of the other copy. Now, this document tells you that you have the right to appeal the sentence that I just gave you. Which, by the way, I didn't really do anything. But, well, I mean, I did. I talked a lot. Boy, I'm sure we all loved it. But you have the right to appeal. If you choose to and you wish to have the court appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. You understand?
I do. Thank you, Your
All
Honor.
right. If you choose not to appeal, simply dispose of your copy of that document in an appropriate trash receptacle.
I think that.
All right. Thank you very much.
Thank you.
Word adjourned. Sam?
McCartney. Where's Terry McCartney? Terry McCartney out there?
He's on Zoom.
Gotta be kidding me. Terry Paul McCartney. 24F242928. Terry McCartney, you gotta start your video and state your name.
Yes, hi, Your Honor. Good morning. Oh, good
Your
morning,
name?
Your Honor. My name is Terry McCartney.
Tell me this is tell me we're gonna be on Saturday Night Live with this one.
Yeah, so I
Listen. Don't walk around. Where you at? Where are you?
I'm at my house. I'm at home. I found out that
McCartney.
I missed a court date,
Mr.
and
McCartney?
I have
Mr. McCartney?
yes.
I wouldn't say anything right now. Okay. You got a lot of gumption calling here and asking for time to pay. Back in October of 24, I said you pay 75 per month beginning November 15 of 24. February 6 of 25, I let you pay 40 per month beginning April 15. Judge Kirsten was in here on July the 11th. He told you of 25, pay 50 a month starting October 1. You were back in front of me December 18 to 25. You pay 30 per month beginning January 15 to 26. Back in April 2nd of this year, I said you were to pay 20 today. Balance will be 174. You were to complete 11 hours of community service or pay 174 by May 15, 26. You didn't do anything. So
Yeah, I
listen,
did,
listen, stop. Shame on me. Shame on the court system.
I did community service.
Not interrupt me, okay? You got it? It's my turn to talk. I'm not giving you time to pay. No way. No way. Defendant to appear in person tomorrow at 8:30 in the morning. You're to appear August the 20th at 8:30 in the morning. If I were you, I'd bring all my money or else my toothbrush and about 6 pair of clean underwear. Okay? I'm not playing with you, Mr. McCartney. You want to play games? Go buy a Monopoly board or listen. No, I'm not giving you time to pay. You're going to be here at 8:30 in the morning, or else I'm going to issue a warrant. And when you're brought in, I promise you, don't.
There is a warrant. There is a warrant.
You have a horrible, horrible habit of interrupting. You know that?
May I speak?
No. You're going to come here at 8:30 in the morning tomorrow with your money, or else you're going to jail. You got it? You got it?
I don't have any money. I'm about to lose
get
my
out and get a
apartment.
job. Are you on disability?
Yes.
You're collecting disability?
Yes. And Yes, and I'm about to lose my apartment.
Listen,
I
listen. I gave you an opportunity to do community service and you didn't do that either.
I did community service. I volunteer with the kids from the Miracle League of Plymouth every summer.
Listen,
So I did that regardless.
listen, listen. You have ignored a court for 2 years. Maybe that explains the disability thing, why I gave you so many opportunities to correct this. It might. It might. Otherwise, I was a bad judge on several days. I gave you the opportunity to do community service or pay the money. You didn't do it. You didn't provide proof of that. Mr. McCarthy, Mr. McCarthy, do not interrupt me. Okay? Do not interrupt me. You forced the hand. You got a lot of gumption calling up and asking for time to pay. I'm telling you, I'm not playing with you anymore. I'm done. I'm not playing games here. You show up here at 8:30 in the morning tomorrow, period. Plain simple. We understand what?
I understand you.
I'll see
I
you at
understand.
8:30 in the morning. Good luck.
Okay.
Demetrius Allen Moore, 26W843-801. Could I have Purdy over here? Austin Purdy seated at the table, my right, your left. Sir, your name? You're charged with driving on a suspended. You were supposed to be here August 5. Where weren't you here?
I can't get the company come today. I can't get today.
They gave you a court date for August 5th. You have the right to a lawyer on this suspend charge. If you want one, I'll give you one. Do you want a lawyer? No? I'll go ahead and arraign you and send you to the prosecutor. On July 20 of 26, it is alleged that you did operate a motor vehicle with suspended license on West near Ford Lane in the city of Woodhaven at 4:58 p.m. That is a misdemeanor drive while suspended, punishable by up to 500 fines, 93 days jail, costs are all those in 2 points. Do you understand that?
Yeah,
Did you sign, read, and understand the advice of rights?
yeah,
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
yeah.
Okay. You have the right to a lawyer. Do you still wish to waive your right to a lawyer? Enter a not guilty plea. $500 personal bond. Here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You don't have to post any money, but you'll owe $500 to the people of Woodhaven if you violate any of those terms. Go sign in next to the prosecutor's conference room right out here, and they'll call you in. My court officer will bring the file to the prosecutor, and then you'll speak to them. Okay? Good luck. People against Moore, Demetrius Allen Moore, 26W843-801. Come on up here and tell me your name, sir. You're charged with driving on a suspended. You met with the prosecutor. You're going to plead guilty to the added count of no ops on person. Is that true?
Yes.
If you plead to that, the possible penalties are up to 100 fines, 90 days jail. Costs are all those, and then I would dismiss the driving on a suspended. You understand that?
Yeah.
Did you sign the advice of rights?
Yeah.
Did you read it and understand it?
Yeah.
You plead guilty, you'll be giving up all those rights, and we're not going to have any hearing or trial. Do you understand that?
Yeah.
Again, you have the right to an attorney. If you want one over the points, you want a public expense. Would you like an attorney?
No.
To that charge, no valid ops on person. How do you plead?
Yes.
Were you operating a motor vehicle on July 20 of 26 at 4:58 p.m. on West near Ford Lane in the city of Woodhaven, County of Wayne?
Yeah.
Did you have a valid license with you on your person?
No.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Plea is accepted to that charge. Suspends dismissed. You got warrants all over. You're gonna get around to taking care of these.
No, I just went to the Secretary of State. I go back to court at Lincoln Park. I'll take one more ticket to get my license.
You got 3 warrants out of Dearborn Heights. You got 1 out of Lincoln. Well, that's with no contact provision. You got another one out of Westland, another one out of Westland, another one out of Inkster, Another one out of Allen Park. 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 Two more out of Allen Park. Another one out of Allen Park and one out of Dearborn. Why do you think this is funny?
Took care of that when I went to Lincoln Park.
You thought you took care of those when you went to Lincoln Park?
You could all portion of one.
Lisa, can you run this for me again? This was run July 21.
Yes.
You're still suspended. You thought you took care of them when you went to Lincoln Park?
You said all
How
that.
many judges did you see in Lincoln Park? When you were, pardon?
So,
Where were they from? The two judges in Lincoln Park?
yeah.
Well, how'd you think you took care of the cases out of Dearborn and Dearborn Heights?
I did more. I gotta go back and
Allen Park? Westland? How'd you take care of those at Lincoln Park?
I don't know about Allen Park though. They all
Where do you work?
do landscape.
Your record's bad. You know that? Mr. Moore, you need to stop ignoring courts. You got it?
Yep.
Do you want me to bring it down, Judge, or just tell
No,
you?
I just want to know, does he have about 14 warrants on there still?
I'm counting still. Yes, there's 14.
You told me you only had to take care of one ticket.
That's what I pay for the car. That's for drunk insurance. So I pay like 5 of them. They said that I went to the judge in Lincoln Park said, go to the Secretary of State, my ticket's old, and I won't have to pay all like $2,000. So I come back on the 25th.
You need to go to the cities I told you. Dearborn Heights, Westland, Allen Park, Dearborn. Start with that. Inkster, then go over to Detroit, 36. Anything else? 100 fines, 250 costs, 75 victims' right, $50 justice assessment, 475 in 90 days. You can pay that now?
I know.
How much do you have today?
I need a couple of eggs.
How much do you have today, though?
I know.
You need a couple days for what?
Get back. Then I'm gonna come make a payment plan.
Yeah, you can make a payment plan. I mean, I trust you're gonna be a lot better about paying ours than you are these ones, right?
Yeah.
Because if not, we're gonna have a big problem. You don't wanna have a problem. It's easy to get along with until you start thumbing your nose at courts, okay?
All right.
So you tell me how much you can afford to pay weekly, and we'll go from there.
Like 50.
$50 a week, starting a week from today or not?
Yeah.
You sure?
Yeah.
Beginning August the 26th, and every Wednesday thereafter until paid in full. Now, if you don't have the money, you call the court, we'll go on Zoom. I'll give you an extension. I don't care if we have to do that 117 times. But if you keep ignoring courts like this, you're gonna run into the wrong judge. And the wrong judge might be me, because I'm not gonna tolerate that nonsense. You got it?
Yeah.
Good. We'll get along fine then. Have a good day. Is this Tiger Sloan by chance?
I don't know. That's why I wanted to bring him in and see.
Good morning,
Judge
Deputy.
McNally.
How are you? How
I
you
just
doing
heard you
today?
say, Tyler Stone, Judge McNally. How you doing this Wednesday morning, sir?
I'm doing okay so far. It's only 9:22, but you don't know how much worse things can get before the
I
end of
tell
the
you
day.
what, though, the only easy day was yesterday, son. I think we can make it, Your Honor.
So Tyler Sloan is who you
Yeah.
have?
Yes, sir. I'm about to bring them. I can bring them up to you now. You ready?
Yeah, I'm ready. I'm always ready. I don't know if the defense lawyers met with him. Does Mr. Crawford represent him, Lisa?
Yes, he does.
So we'll put him in a breakout room and he can speak to his lawyer and I'll get him out of there as soon as they're ready. He's got a
Okay.
lot though, Mr. Crawford does. So I try to not keep you guys waiting. So it won't be me, I promise you.
Yes, sir. Thank you, sir.
All right, thanks.
You're welcome.
People against Tyler Wayne Sloan, 26W841-843A. Mr. Sloan, your name?
Tyler Sloan.
All right.
Good morning, Your
lawyer's
Honor.
making his way in, and he's going to state his appearance. Your appearance, Mr. Crawford.
Morning, Your Honor, Mike Cole.
Today is the date scheduled for sentence. Your client's been in custody, it looks like, since July the 27th. Judge Hessen set a bond on that date. He pled guilty on August the 5th to the charge possession of a controlled substance. This, of course, involved cocaine and heroin and meth he had in his possession, or at least used it on the probation's recommending jail. Have you had a chance to review the report with your client, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, Your Honor. There are no material deletions or additions that were requested at this time. My client will request, of course, considering jail time. He's asking time served, Your Honor. He reports he's been in jail for 5 months.
5 months. How you been in custody for 5 months? Can you check on that, Lisa?
He's been held also on a probation violation out of Third Circuit Court, and he said.
And I was also in custody in Monroe counties since March 3rd.
Well, that just tells me you get yourself in a lot of trouble, Mr. Sloan.
Judge, it shows a booking date of June 4th with Wayne County.
June 4th in Wayne County. What was that on?
Probation violation through Third Circuit.
Did they sentence you on that?
Not yet.
They haven't sentenced you at all on that?
No.
When is the sentencing date?
September 10th.
What kind of bond do they have on that case?
I'm remanded.
Nice. Well, you got to stop getting yourself into so much trouble. You're going to ruin your life if you haven't already. What are you, 34, 33?
33. I'll be 33 this year.
What in the world are you doing? Are you still married?
Yes.
And does your wife live with your parents too?
No.
Where does she live?
We're currently separated.
Can I ask you a question? At what point are you going to stop this nonsense?
I'm trying to get my life together now. I'm wanting to go to rehab.
You got a 9th grade diploma. You've been unemployed for a year. Before that, you worked at Holbrook. You're married. You're separated. You pay $96 weekly in court-ordered child support, and you never got past the 9th grade. Now listen, life is hard. Life is hard. It's got to be darn near impossible if you don't have a diploma and you don't have a job and you're drugging and drinking and doing everything else. Now you can do that. You can do that. Nobody's going to stop you. They can't stop you. They're going to incarcerate you. But it is time for you to grow up. I mean, you're 32 going on 9. So I don't know. I don't know what to tell you. I'm telling you, it sometimes seems more, to me at least, that it bothers me to see people ruin their lives more than it does them. They don't give us a chance. This is not a second do-over here. We don't get instant replay. We don't get to go back and undo our mess that we've created. You know what I mean? I don't know what to do with him. I mean, I guess he's been in custody so long. It's just, how, can't be any fun in there, is it?
No, Your Honor. Like I said, I was hoping to get sentenced to some inpatient rehab. I'm trying to go to a lockdown facility. That way I can try to get my life together here.
Wow. Tell you what. I don't have to give you credit for that time. You understand what I'm telling you?
Yeah.
So you've been in custody on this case for 23 days. I'm simply going to say fines 100, costs 250, 75 victims' rights, $50 justice assessment. That's 475. Screening fee 60 for 535. You know what? I'm not even going to fine. I'm going to simply order 45 days jail. I'm going to give you credit for 27, 28, 29, 30, 31. That's 5, 24, 23 days credit. Serve 22 more. That'll take you to the date of your sentencing on the felony charge, and you can talk to the judge there about getting in rehab. I don't know what else to tell you. I just wish you'd stop ruining your life. I wish you well. I hope you're at least reflecting on what you're going to do when you get out of there to try to improve your life. 32 and living with your parents is no way to go about living, son. You got kids. You got kids? You got 2 kids?
Yes, Your Honor.
Well, you're not being a very good example. So unless you want them to follow in your footsteps, maybe you should try something else. Try making an honest living and staying away from the drugs. I don't know what to tell you. I wish you well. Good luck. Thank you.
Thank you. Have a good day, Your Honor.
Is Courtney Regina Simpson?
Hello, Your Honor.
Proper as well.
Did I tell Ms. Simpson she could appear by Zoom?
Yes, Your Honor.
All right. People against Melissa Renee De Palma, 24W835-466A and B. I also have 23W 832679A and B.
Good morning, Your Honor. Michael Brown there. All station correct.
She pled guilty to retail fraud emanating from a December 29, 23 incident. She also pled guilty to giving false information to an officer. She also has pending in front of Judge Hessen refused to obey a police officer and retail fraud. She's not been sentenced in there yet, right? So I don't need to worry about those. Did you review this report with your client? Are there any material additions, corrections, or deletions?
My client, there are other material additions, deletions, or revision that we asked for in line. She understands what the recommendation entails. She believes she can comply. We asked the court to adopt the recommendation as presented.
I have to be honest with you. Why am I putting her on probation again? Why would anybody expect her to go on probation in front of me?
I can't speak much really fast.
09, retail fraud. Larceny by conversion, 13. Retail fraud, 14. Retail fraud, 16. Retail fraud operating while impaired, 26. Another retail fraud and refusal. I mean, I don't know why. I don't know why they would recommend this. I'm sorry, I just don't.
Well, Your Honor, my client needs some help, and she admits that she needs some help. She's got a problem. She started the process of trying to get some help now. So her thought, and my thought, I agree, is that the court can help by putting her on probation, give her some guardrails, making sure she gets in an instance of outpatient substance abuse. She wants to get this under control. She knows her past is terrible. She knows the prospects aren't good. She continues down this road. She wants some assistance. So I think that's why the court might consider probation.
Anything you'd like to say, Ian?
I mean, I've had to go to the home for quite some time, I am, I'm starting to get it under control.
You what?
I'm ready to get it under control.
On the false information, 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4 or 90 days. On the retail fraud, 100 fines, 250 costs, 75 victims' rights fee, $50 justice assessment, 475 and 45 days. I'm going to add 45 more if you fail to pay your fines and costs on that. I will let you pay these at the rate of $25 per week, and I will start that beginning on October the 30th. If you don't have the money, you come talk to me. And actually, on the false information, I'm simply going to make that easier. 3 1/4 or 45 days. So that'll be taken care of. You have a bond that's the name of a third-party poster, I believe, Lisa, on the, yeah, it's a third-party
Yes,
poster.
third
So
party.
So that's what I'm going to do. We're going to close out the false info, or at least, and the other one, she'll just, third-party poster can get them. I'm sorry, Mr. Palmer. Let it go too far. I wish you well. Have a seat. You have 21 days to appeal, 14 days to apply to a court-appointed lawyer for purposes of appeal. Good luck. These are going to Judge Hudson. You can tell her I gave her 45 days. Thank you. Courtney Regina Simpson, 26W843-720.
Yes, Your Honor.
Name,
Courtney Regina Simpson.
counsel.
Well, Your Honor, like the law representing Ms. Simpson.
All right. If you had a chance, she pled to retail fraud under HIDA. Have you had a chance to review the report, whether or not are there any material additions, corrections, or deletions?
I have had the opportunity to report my client, Your Honor. There are no material additions or revisions that we asked for. She believes this is reasonable, so she should be able to comply with, Your Honor. My only concerns are that the court keep in mind the fines and costs or circumstances we can discuss.
Say that again.
The only issue, Your Honor, will be her being able to pay fines and costs in view of her circumstance, which we can discuss when the court's ready.
Okay. Ma'am, anything you'd like to say?
At this moment, no, Your Honor.
I'm trying to figure out, when I read this, you graduated from high school. You're going to be a sophomore at Grand Valley State. I'm trying to figure out why in the world you would do this. I mean, you might as well just save all your tuition and book money. Whoever's paying for it, whether it's you with student loans or you because you're trust fund baby or your parents are paying for it, or I have no clue. You might as well just save all that money. Why would you do this?
In the moment, I feel like I was under pressure when the
Under
situation
pressure.
was
Let me
going
tell you
on.
something. You're going to be under pressure your whole life, young lady, to do stupid things. I mean, I'm serious as a heart attack right now. This is disappointing to me. This is really disappointing that somebody that I see has a world of potential here would be going in there and doing something stupid like this. This is stupid. It's just stupid. And I'm telling you, you start racking up criminal convictions, forget it. Don't go to school, save your money. Under pressure, come on. Under pressure. Nobody had a gun they were pointing at you, did they?
No, Your Honor.
Well, come on. Are you going to be a leader or a follower? Are you going to listen to people that are stupid and doing dumb things? Or are you going to be the leader and say, hey, we shouldn't be doing this? This is wrong. We can't do this. We're not thieves. I'm serious. I remember you before. Nice girl. You seem like a really nice girl. You really do. You really do. And please don't tell me this under pressure stuff. You're going to have pressure your whole life. You're going to have pressure to do well in school. You're going to have pressure to make money. You're going to have pressure to be a good parent, to marry a good spouse, whatever the case is. It's just the way it is. I mean, we don't live in la la land here. I didn't want to hear that from you. I want to be honest with you. I didn't want to hear that from you. I mean, you got a 6 months probation. You cannot leave the state without the consent of the court or violate any law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. You're not to enter 22600 Allen Road in Woodhaven or any other miter store. I am taking this under HIDA.
Is it possible that we could work with something to get it off of my record by me wanting to get into things with school?
Yeah, but you're going to use your brains going forward, okay?
Yes, Your Honor.
I don't want to hear this stuff about under pressure. 12 hours community service I'm going to have you do by October the 1st. I'm going to go light on your fines. You have 120 in probation fees, $60 screening fees, 75 victims' rights fee, $50 justice assessment. Fines are 50, costs are 25. So I'm going to go light on you there. That's 200 plus your screening fee is 260 and probation fees are 120 for a total of 380. That's light. 12 hours community service, stay out of Meyer. I'll take it under HIDA. You comply. This case will be dismissed. I'm serious. You seem like such a nice girl. I remember you from before. When I read this morning, I got sick to my stomach.
Yes, Your Honor.
I'm going to give you another review hearing date. You talk to me about when she can pay. Give her a review hearing date, please, Lisa.
February 3rd at 9 o'clock.
February
Wait.
the 3rd.
I'm sorry, you was cutting out. So is it possible you could repeat yourself starting from a hearing date? I didn't hear anything.
No, I'm giving you a review hearing date so you can have the case dismissed if you're compliant. I'll let you appear by Zoom. That'll be February the 3rd at 9 in the morning. Okay? And that will be to have the case dismissed, assuming you're compliant. Tell me how much you can pay per whatever it is, week, bi-weekly, monthly.
As the court knows, she's in school. She headed back on the 28th. She tends to find a job at that time. She's asking the court to be particularly lenient, but she thinks she can pay for sure $30 a month starting August the 31st.
No, I can't do that.
I know, Your Honor. But
you got to have all this paid by February.
I could do 50.
My client doesn't have any financial support. Her mother's passed away. Her father is not contributing to her schooling. She's doing this completely on her own.
$50 a month beginning September 15th. I can make it to September 22nd. But all money due by January the 20th, okay?
Could I start sooner? Is it possible I could start sooner?
You can start whenever you want. I'm just trying to give you, I just want to make sure you can pay this. So $50 a month beginning September 22nd. Just stay in accordance with that schedule, but all money due by January, what did I say? The 20th of 27. And the review hearing dates, February 3rd at 9 o'clock. You have to have 12 hours community service done by October 1. If you don't have the money on any given date, no worries. Just call the court. We'll go on Zoom. I'll give you an extension, okay? Don't let yourself down. Do not let yourself down again. Do you understand what I'm saying?
Yes, Your Honor. Where could I start paying my bill and see information regarding my bill and to start paying sooner?
Lisa, have her wait around, and probation will instruct you by video, okay? They'll come on and instruct you by video. Can you call over to probation, please, Lisa?
Sure.
Thank you. All right, so
Thank
just
you,
stay
Your Honor.
right there. We're gonna put you in a breakout room. Don't let yourself down,
Okay, thank
okay?
you.
Good
Yes.
luck. Study hard, work hard. That's what it's about.
So I got a phone call from Melissa De Palma, who's in custody back there. She's trying to get out of her jail sentence. She wants to talk to you again. I said, once you go back there, there's not really a
No.
redo again. But I said I would ask, but I just wanted a heads up that she's giving them a hard time wanting to come back in here. She's giving John a hard time. So,
Well, maybe I'll have her come back in. Let me take care of it.
okay, no
Have
problem.
John bring her back in, but I need the file again.
Okay.
Mrs. Palmer,
Go to break the poll.
I need her file. Do I have her file?
I don't know, Judge.
Okay, don't get frustrated. What's the case number, Sadie?
I think Justice said it's still on the thing here.
Oh,
Somewhere there.
okay, I got it. 23W832679A and B. Your name?
Melissa, you need to find.
I'm not gonna change my mind. You can't keep doing this.
And I promise you, if you just give me this chance.
No.
I will not upset you.
No,
Try-
no, you've had 5 or 6 of these. You just got another one in front of Judge Hessen. No. I'm not gonna change my mind, and I don't want you giving these guys a hard time to. Ma'am, listen to me. You have led a life of crime.
I understand it.
I'm not gonna change my mind. I don't get up and just decide over willy-nilly over what I'm gonna do here. I have done something. I didn't give you 90 days. You deserve 90.
Can I at least get a second good here in order?
No, I'm sorry. You cannot keep doing what you're doing. No. You just did this in front of Judge Hessen. You just had another case in front of Judge Hessen.
I know.
You've had 2 in the last year. Don't tell me you've seen the errors in your ways. I've never had one person come in here and say, I'm gonna do this again.
No,
I don't care what you think, Judge. I've never had one person do that. Listen to me. I don't want you giving these guys a hard time. I've made my decision. I'm not gonna change my mind. If you say something, I'll let you talk. But if I let you talk, I might make it worse. Do you understand what I'm telling you? This could have been worse. It should have been worse. Do you still want to talk? Pardon? Go to the back. I'm sorry. Good luck.
I'm not saying a word, sir. I have nothing to say. Please just send me to jail for 45 minutes. I don't want to do 90. No matter what. Keep your mouth shut, lady. She called. How? She called from the back and got the judge's staff on the phone? When have we ever seen a defendant do that? I mean, that's brains. That is honestly brains. And she was like, give me the judge's staff on the phone right now. I'm using my one phone call to call the judge right now. He's kind of an entitled idiot. He's back. Thank you, Soldier of Providence. Thank you, everybody out there. Get these most especially thank you X25. I didn't stop and give a proper thank you. I never did. Not what I do, you know. But I am gonna give you a great big old thank you so very much for that super chat. So amazing. Thank you. Oh my god. Oh dear Lord, thank you all for hanging out tonight. Miss Good Kitty, Mark Baggett, great to see you. Haven't seen OSG in a couple of days. Hope he's doing okay out there. Hey Specs. Hi. Marty. I see you. Squirrel. Dixon. I actually had a case. There's a Dixon case with Judge Stevens. Actually, the person on trial is actually not named Dixon. I believe the Cena was named Dixon. Lord. It's been one of those days, ladies and gentlemen. One of those days. a lot of court. I mean, Judge Elmore literally gave Judge Rossi a run for his money with that lecture. I rarely see lectures like that in court cases. I haven't seen it. You probably haven't seen it. That was interesting, to say the least. Everything he said was accurate, poignant, and interesting. Just all there is to it. All there is to it. Yeah. So, well, another day in the book. Judge Dad was mad. Put some people in jail. Told some other people they needed to show up tomorrow. We'll see if that happens. Definitely watching for that. Oh my God. Thank you all very much for hanging out with me tonight. Mama Wolvie, thank you for hanging out, watching over the chat. Mama's always great to have around. Listen to Mama. Have a great rest of your evening. Make sure you tune in tomorrow. I'll have more Same Wolf Time, Same Wolf Channel. It's 8 p.m. Central, 9 p.m. Eastern. And I am your lone wolf booster. I know nothing about Tupac. I don't know anything about Tupac either. I don't know the guy. And all I have to say, from this wolf's mouth to your ears, is a hearty meow. We'll see you next time. I am your lone wolf booster. I am out. And remember, only you can take a bite out of crime. Bye!